Well, welcome everybody to the IAPP web conference, U.S. Privacy, the California Consumer Privacy Act and the GDPR, brought to you today by OneTrust. My name is Dave Cohen. I'm the IAPP's Knowledge Manager. I'll be hosting the program today. We're going to get started with the presentation in just a minute, but before we do, I wanted to cover a few details. Participating in today's program will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Everybody else who's listening in can apply for those credits through an easy-to-use online form on our website under the Certification tab. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. That's going to be posted on the IAPP website. We encourage you to ask questions at any time during the program by typing them into the Q&A field that's just to the right of your PowerPoint window, and we've reserved a question and answer period toward the end of the webinar. So now onto our program, and I'd like to briefly discuss what we're going to be covering today. In a moment, I'm going to be introducing today's panelists, and then we're going to go over for you what the data subject requests are for the GDPR and the CCPA, and then we're going to talk about, importantly, where they overlap and what are the differences, and we're going to finish the program by talking about how you can begin to think about and actually implement operationalizing these data subject requests. We're going to leave you with some takeaways and some other information about some upcoming events. We are going to take some time to answer your questions, as I mentioned a moment ago, and then we'll wrap up the program. So with that, and without any further ado, I would like to introduce today's panelists. Andrew Clearwater is the Director of Privacy at OneTrust. He's a fellow Mainer right up here with me here in Portsmouth, New Hampshire, up in northern New England. Andrew, welcome to the program, and can you tell us a little bit about your position down there at OneTrust and your background?
Of course, thanks, Dave. Yes, Andrew Clearwater, Director of Privacy at OneTrust. I'm an attorney at US with an LLM in global law and technology. I work with Benedict in our privacy program at OneTrust, and I was previously a privacy officer in the healthcare space, and I've worked on privacy policy through Future Privacy Forum and Harvard's Berkman Center.
Terrific. Thanks, Andrew. Welcome to the panel. And joining Andrew on the panel today, Benedict Dumbreen is Privacy Counsel of OneTrust, coming today to us from their offices down in Atlanta, Georgia. Benedict, welcome, and can you tell us a bit about your professional background?
Yeah, of course. Hello, Dave. Thank you, and hello, everyone. So I'm Privacy Counsel at OneTrust, as Andrew mentioned. Work closely with him to handle our privacy program, and also I've been focusing on CCPA since it was passed. And prior to being at OneTrust, I worked at the Future Privacy Forum in DC as well, and also at a firm in Paris on different privacy and corporate issues.
Wonderful. Welcome, Benedict. And to round out our panel today, coming to us from another far corner of the United States out in Los Angeles, Dominique Shelton-Leipzig is a partner for the Privacy and Security practice in Perkins Coie out in LA, and is also co-chair of the AdTech Privacy and Data Management team. Dominique, it's great to have you with us, and can you tell us a little bit about your practice?
Yeah, well, thank you, Dave, and I'm really excited to be on the panel with everyone. As you said, I'm a partner in Perkins Coie's Privacy and Data Security Group, and I chair the firm's AdTech Privacy and Data Management Group. And in these days, I've been focusing a lot on data strategy and management for companies, because there's so much going on with all of the evolving areas of law. We're going to talk about CCPA, but GDPR, and then all these new other bills coming up. Been really working with clients to figure out a top-line compliance approach.
Great. Thanks, Dominique. And with that, we've got a lot to cover today, so let's go ahead and get started, and Dominique is going to get us going today. So, Dominique, it's all yours.
Thanks, Dave. So, first, we thought we'd just talk about data subject rights in the GDPR, because it's sort of the basis for how we're going to compare the rights that are available in California. So, of course, with GDPR, you've got a right to access that's in Article 15 that EU residents have. They have the right to correct the data and request that under Article 16. They can, data subjects in the EU can also make erasure requests, but there are some specific limitations as to when erasure requests are valid. You can only bring them under certain circumstances, and so it's very important to realize that erasure requests are not just automatic in the EU. Then data subjects have the right to restrict the processing of the data. They have a right of portability. They have objection rights. They have the ability to object to automated processing. And even though it's not really stated as a right, they do have, I just put here the transparency obligation that companies have because under the GDPR, they do need to have transparency with respect to their consumer notice under Article 13. So let me just move on here to just talk about the post-GDPR landscape. So as you guys, probably heard right after GDPR went into effect on May 25th, the data protection authorities, or I guess supervisory authorities now throughout the EU, were just deluged with thousands of data subject rights requests and thousands of data subject rights claims that followed data subject rights requests that were sort of thrown on companies. And so one of the things that has come up is that because the data protection authorities have been so busy in the EU, many companies, and there wasn't a real process that's been outlined in Article 80 for getting information to companies about the complaints that have been lodged against them with the supervisory authorities. It's only months later that many of the companies started getting copies of the complaints to see what had been actually lodged against them with the supervisory authorities. Just to, back up a little bit, there's also, in addition to the complaints that are coming in, I'm going to talk to you about some specific claims that are being asserted, but in addition to the complaints that are coming in, there are also sweeps that regulators have been sort of initiating to be able to check GDPR readiness. And so we have here on the slide the Dutch Data Protection Authority looking into whether there has been sufficient compliance with GDPR through a selected group of companies. I think about 100 or so have been selected in various different industries, and they're focusing more on whether the Article 30 reports exist and are up, are appropriate. With respect to to swing back to the litigation front for a second, obviously Max Schrems nonprofit group NYOB.EU filed 4 actions on May 25th. That's none of your business.eu for those of you that don't know about it. They were against Google and then Instagram, WhatsApp, and Facebook more broadly. Those complaints were actually lodged with the regulators under Article 80 as representative actions, which nonprofits are allowed to bring representative actions under the GDPR Article 80. Subsequent to that, on May 31st, there were another group of representative actions that were filed against Facebook, Google, and Apple, Amazon, and LinkedIn. And those complaints are publicly available, and those were all filed in the French with the CNIL in France. And then there's been a bunch of additional questions. France has sort of turned into a hub of a lot of these complaints. Just to give some sense, so we don't have all of them, but just in the first 24 days after the GDPR, a little over 400 complaints have been filed. And that's from some IEPP data, actually. Then here, stateside, we have seen a wave of collective actions that have been filed in the U.S. recently, basically in the form of shareholder derivative actions, challenging companies for misrepresenting or allegedly misrepresenting the state of their GDPR readiness. What's interesting to me, and the Nielsen complaint that was filed, is that this was not triggered by any complaints that had actually been lodged with supervisory authorities or complaints from EU residents about Nielsen's GDPR readiness. This is just, a shareholder, that filed this lawsuit in the Southern District of New York, an American shareholder that filed the lawsuit, taking the position that the GDPR readiness was not was not properly stated. So that's just something to give a sense that, I guess I'm going to give you like a little preview here of the difference between how the Europeans are reacting and our culture in the U.S. of litigation activity. So, there are lessons that we've learned, obviously, in our class action history in the U.S. that show patterns that we're starting to see that are arriving in the EU with respect to these representative actions. So we're seeing coordinated activity. There's a number of different organizations that have been involved, La Quad in France, NYOB.EU, and many other consumer groups are putting on their websites sort of, preset consumer or preset data subject requests that data subjects can assert about complaints about these days they're focusing on the scope of consent on a website. That's what we've seen. But there are turnkey tools that consumers can use to assert claims against companies in the EU. The other thing that's happening, which is we've seen this reflected, it's sort of from the playbook of what goes on in the U.S. A number of companies they got these the data subject requests, thought they might have only received one or two, and when they actually dig under the hood or they actually get served with the actual complaint that's been filed with the supervisory authority, it's then that they learn that literally hundreds of complaints of data subject rights requests have been asserted against the company through the website or through a help desk or through other, various means, writing to, individual employees. And the problem there is without a coordinated strategy, you've got companies that are providing different, varied responses to different requests. And then there are also another thing that we see a lot in the U.S. that we're seeing in the EU with respect to these data subject requests. They're sort of predicate acts that they are including in these demands that assume certain facts that may not be actually correct. So before I leave the slide, just to give an example, very common risk that we're seeing is that companies are receiving data subject requests that say, delete all my data because, delete all my data because I'm withdrawing consent. And if the deletion or erasure request is based on marketing data, for example, and the company is actually relying not on consent as a valid legal basis, but rather legitimate interest, many times companies are not making that differentiation. They're just responding to that data subject saying, oh yes, we will delete your data within the next 30 days, only to find later that when the complaints are filed against the company and the supervisory authority, those responses are being used as predicate acts to claim that the company has admitted that they are relying on consent as the basis for processing the data because they responded to the data subject request without clarifying that they were relying on another valid legal basis like legitimate interest for their marketing. Okay, so what have we seen on the fine front? We haven't seen huge fines yet out of the EU with the regulators. Of course, we've heard about 4% of global turnover or 20 million euro, and those larger fines are anticipated to start rolling in 2019. But so far, the fines have been relatively low, as indicated on this slide. I think the largest fine has been issued by Portugal for 400,000 euro. What's important for GDPR in terms of the next phase, now that so much preliminary work was done to get compliant, the important thing now is to pay attention to keeping up the compliance, but also paying attention to defenses when you are responding to data subject requests. So I just put here on the slide, we have a GDPR legal playbook that we've developed for clients, but many other companies have, can think through what works in their environment. But, there, as I said, for the erasure request, for example, you can only make them under the GDPR under, a set of circumstances which are listed here, like the data is no longer necessary for the purposes it's collected, or consent is withdrawn, or they can challenge legitimate interest, or there's, various other means. And if there is a defense, even if you are going to voluntarily comply with the request, it's important to indicate that, yes, we will delete your data in 30 days, but just we want to make it clear we're not processing it on the basis of consent. Or if a valid erasure request has not been asserted, to make it a point, even if you are going to comply with it voluntarily, to make it a point that a valid request has not been made by the user. Very important to preserve defenses for litigation risks ahead. So that takes me to discuss, the CCPA, because the California Consumer Privacy Act does also, provide a number of data subject rights requests. And just as a brief primer, I think most of you probably already know this, but the law actually goes into effect January 1st, 2020. It gives California consumers a lot of rights that they did not have before, and germane to this discussion and why we're talking about it now is it gives California consumers the right to have a 12-month look back. So January 1st in 2020, California consumers can reach out to companies who collect their personal information or sell it and ask for information about those processes going back 12 months prior. So what companies are doing today, literally this month in 2019, to be able to track California data disclosures will have a direct impact on their ability to respond to these requests come January 1st, 2020, a year from now. The law applies to, gives these rights to consumers, and consumers are defined as just any California resident who's, and California resident is defined in our tax code, and that definition is tied into in the CCPA. It means anybody that's in California on a non-temporary basis. So that's just, kind of a very broad group. It gives California consumers or California residents here the rights against businesses, and then not every business is covered. It's a company that's doing business in California and collects personal information of California residents that also has one of the three things here below, and they just need to have one of them. Either the company has in excess of $25 million in revenue, or it buys or sells or shares personal information of 50,000 or more California consumers, or it derives 50% or more of its revenues from selling personal information. With respect to the second prong for businesses of collecting more than 50,000 or more, collecting personal information from 50,000 or more California consumers, that might seem like a lot, but if you are able to if you have a website and you're able to geolocate either through IP address or otherwise the location of the residents, then that's going to be sufficient. So in terms of the new rights, let me just drill down very briefly and then talk about some things more specifically. There is an abbreviated right to know about data that is collected, the purposes and the categories of data that are collected under 1798.100A. There's an expanded right to know that California residents will get to know about how their data is used from companies that collect personal information, and that's under 1798.110. There is also a right to know about the sale of personal information and also disclosures for a business purpose. So I wanted just to emphasize this. That's under 1798.115. I hear a lot about companies attempting to make a distinction between sale of data and whether something should constitute a sale. First of all, the definition of sale is very broad. It includes any exchange for valuable consideration, but even beyond that, 1798.115 does give California consumers the right to know about disclosures for a business purpose. So just be aware that there's that component. There's a right to opt out of the sale of personal information for adults and a right to opt in. In other words, companies are prohibited from collecting personal information, from selling personal information from kids without opt-in consent, and the kids can provide that at ages, between ages 13 and 16, and under the age of 13, parentals need to provide that opt-in consent. There's also a right to access and portability under 1798-100D, and then there's a right to deletion, which is similar to the erasure right, although there are a few more defenses to deletion rights in California, and then there's also a right not to be discriminated against for asserting any of the rights that are 1 through 7. So I'll be, brief here, but just to go over some of the details of these rights, we put these slides together to provide more specifics. So for the abbreviated right to know for 100A, 1798.100A, a consumer can make a request of a company, a verifiable request to know the categories of PI collected and the specific pieces of PI collected about the consumer, and the purposes of that collection. The second consumer right, which has to do with the expanded right to know, the consumers can issue a verifiable request to a company to know the categories of PI collected, the categories of sources from which the PI is collected, the business or commercial purpose, and the categories of third parties with whom the business shares. In addition, the specific pieces of PI that the company has collected about that particular consumer can be requested. The expanded right to know also includes a requirement to include some of this information in a privacy policy, but I want to focus on the specific request, the verifiable request that consumers can assert, because that requires a level of granularity that may not, that companies may not be thinking about it just generally. So then I want to go to the consumer right number 3, the detailed right to know about personal information that's sold or disclosed for a business purpose. Within 45 days, the company needs to identify the category or categories of consumers' PI that's actually sold by the business, and also the categories of PI that are disclosed for a business purpose. And they need to be provided in 2 separate lists, and there's specific requirements about the format of how that information is disclosed. With the right to opt out, once a consumer, an adult, asserts the right to opt out of the sale of their personal information, then that opt-out must be respected, and you cannot attempt to change the consumer's mind or get them to change their decision to opt out for at least 12 months. So there's back-end compliance that companies need to put into place. With respect to the right to opt in, as I said, you can get consent from children between the ages of 13 to 16, but you need their opt-in consent to sell their data. And for kids under the age of 13, that you need to have a parent or a guardian give you consent for the sale of the data. So this goes beyond COPPA with respect to the 13 to 16-year-olds. With respect to the consumer's right to access and portability, this is the 6th right, and this is under Section 1798.100D. If a consumer asks to access the data, you have to take steps to disclose it, and then if you're providing it electronically, it should be in a portable fashion. I want to pause here. As I've been describing all these rights, I just want to make it clear there are a number of defenses to each of them that are both general and specific, but just as I progress, I'm giving you the rights, but I'm not giving you every single defense that would go with them. Then the 7th right, the right to deletion, once you receive a valid deletion request, then you should delete the data on the basis of a verifiable request. And what constitutes a verifiable request will be forthcoming in guidelines that are being promulgated, being discussed and created by the California Attorney General's office right now. There are public hearings on that topic, as well as various others that the California AG is involved in developing. They've specifically really asked and called for comments from industry. We have been covering the hearings, the public hearings on our end, and I know IAPP has as well. Been really surprised at the few number of comments that are coming through in public hearings, and so many industry verticals that have not been really represented in public comment. So just wanted to let you know that on our portal at perkinscoie.com/adtech, you can find a link where you can provide comments, specific comments that relate to your industry that will be provided to the AG's office in an anonymized format to at least get the business perspective out. And then the 8th consumer right is the right not to be discriminated against. This means that you cannot provide different levels of quality of goods and services for consumers exercising their right not to have their data either sold or any other right that they might have asserted to request data under rights numbers 1 through 7. You can, however, provide financial incentives for data, and it has to be linked to the value of the data. So conversations right now to be had with your marketing teams and others to help figure out the value of data for things like loyalty or coupons or other sort of promotions that you might want to give. And before I get to the independent business obligations, I'll just say it's kind of interesting. My old alma mater at Brown University, there's a cafe that literally allows students to come in and provide their personal information as the actual consideration for the coffee, or they can decide to pay for a cup of coffee. So you might see more sort of transparent things like that popping up post-CCPA. The other thing, so I talked to you about all the business obligations that go with the consumer rights, but there are 3 independent business obligations I want to bring to your attention. Number 1, and these are not tied to any particular consumer right, but they're required under the statute. So companies must train those employees that will be responsible for answering questions about personal information and handling personal information about the consumer rights that California consumers do have. They must also create designated methods for asserting rights under the statute, and there's some specific guidance in the statute. Some suggested ways for giving methods for asserting rights are an 800 number, and if a company has a website, for a website icon or notice so that consumers know how to assert their rights. But the California AG, again, is going to be promulgating regulations on this very topic, and it's an opportunity for business to get involved. And as I said, we had a representative from the California AG's office speak in our office, Ellie Bloom, and she specifically called for business comment on these topics, among other things. And then you can also obtain immunity. A company, if they want to obtain immunity for any violations of the CCPA by their vendors, then they must include certain verbiage in their contracts. And a lot of this does match the verbiage that is in Article 28 in terms of the vendor not selling the data or using it for any purpose that's not authorized. But then there also should be a certification that the data will be, that laws will be complied with, and that those working with the data will maintain confidentiality and integrity of the data. Okay, and with that, I just will wrap up here really quickly with the defenses. So there's some general defenses and there's specific defenses. I'm just going to give you an overview of some of the general ones. A company could say that they're not a business if they don't meet the threshold, that you're not dealing with PI. Personal information is defined in the statute under 1798.140, and there's some specific things in the PI definition like, inference data and biometrics, which includes facial recognition for you to pay attention to. But if you're not collecting the things that are in 1798.140, you could take that position. Data is collected for a single one-time transaction, or the data would require a business to re-identify information. If you're, another defense is if the information is publicly available and you are using it in a way that's consistent with the way that it was made publicly available by the user, that is another defense. There are applicable exemptions in the statute for things like data that's that's collected pursuant to GLBA, but keep in mind those are not, a lot of those defense exemptions have loopholes in them, so you need to really look closely, like, what, for like a website for a financial institution, they might be collecting cookies for non-customers, and they're, you're outside of GLBA at that point. So just really look closely at those exemptions, but you might have abilities to assert a defense there, or you can't respond to the request because you don't have enough information to verify the identity of the user, and look out for guidance from the Attorney General's office in May on that topic. We have a legal playbook at our firm really about how to preserve the defenses, similar to what we did with GDPR. And here's some, examples of, specific things that could be included in an abbreviated response. And with that, I'm going to turn it over to Bénédicte.
Great. Thanks a lot, Dominique. Thanks for this very deep dive into, the different rights that are available in the CCPA and GDPR. For the background too at the beginning, that was very informative and very helpful. So I think with that kind of first part, it's fair to say that it feels pretty overwhelming, probably especially for companies as well that are maybe only based in California and we're not subject to GDPR, so haven't been looking in the GDPR considerations for a while. And there's definitely a lot in both of these laws. And now we're kind of in that second part going to look at what you can do in practice within your organization to address all those requirements in the most efficient way possible. First, I'm going to just take a bit of a step back and look at the more bigger pictures, because today's topic was with both laws, not necessarily just the rights, even if it's definitely the most prominent part, especially in CCPA. But there is some other key overlaps in the law that Dominique touched on a bit already, but that I will cover in a bit more details right now. So there's some overlap on the type of data that's concerned, the entities and the individuals who are protected. The GDPR defines personal data as any information relating to an identified or identifiable natural person that the law calls data subject, and defines an identifiable person as one who can be identified directly or indirectly, in particular by reference to an other identifier, online identifier, and it gives some other examples as well. So bottom line here is that it's a very, very broad definition, and CCPA has an equally broad definition of what it calls personal information, as information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Important here to kind of point out this household addition that we don't usually see, and that can add things up pretty quickly. So obvious identifiers that we know, such as name, social security number, but also some more interesting ones as internet or other network activity information that includes browsing history, search history, and there's also this interesting one that any inference that is drawn from any of this information is being used to create a profile about a consumer. So in CCPA as well, extremely broad definition of personal information. One difference, though, to note is that personal information in CCPA does include some exception. Dominique mentioned it a bit earlier, and it excludes publicly available information. So it has a definition of it too, which is information that is lawfully made available from federal, state, or local government records, provided that data is used for a purpose compatible with the one for which it's maintained and made available in the record. Quick note here also is that CCPA has some exclusions from its overall scope of application. And for example, medical information governed by other laws, such as any medical information that's governed by the Confidentiality of Medical Information Act, or another example of exclusion would be personal information that's collected, processed, sold, or disclosed pursuant to the Gramm-Leach-Bliley Act. So those are just a few examples, but that can, to a certain extent, narrow that definition of personal information. And regarding the entities that are covered, there is some, but CCPA is fairly narrower than GDPR here. So GDPR applies to natural or legal persons, so that means people and companies. So that includes associations or non-for-profit public bodies and institutions, whereas, as again Dominique explained a bit earlier, CCPA covers only for-profit entities that do business in California and that meet one of the thresholds that she presented. So a bit narrower in that sense. That said, those thresholds can be met pretty easily, especially the one on the 50,000 or more consumer household or devices can add up pretty quickly. And finally, so GDPR covers data subjects where it's identifiable natural persons only, so it doesn't include companies, and CCPA covers consumers who are California residents. Very quickly too, we've kind of already touched on that, but another area of overlap concerns children, and it's just the interesting point here to make is that there's a particular attention and the recognition that children's data need a higher level of protection in some circumstances. So CCPA has a blanket prohibition for the sale of children's data for children under 16, requires opt-in and the parent's authorization if the child is under 13, from the child himself or herself if under 16, and GDPR only that child's consent requirement only applies in relation to the offer of information society services directly to the child. So that's a bit narrower, and it requires seeing the parent consent or the child depending on the age, and those can vary per member state. So there's undoubtedly some overlap between the two laws, but there are also some important differences. So GDPR is much broader than CCPA overall. The European law applies to the processing of personal data wholly or partly by automated means or non-automated means if the data is part of the filing system. And the term processing itself, which is defined in the regulation, could hardly be broader. And it covers any operation or set of operation that's performed on personal data, and it includes anything collecting, using, disclosing that are the most obvious ones, but also structuring, storing, recording, making available, and so on. The CCPA, on the other hand, is a bit narrower in that obligations are imposed on businesses that collect, sell, or disclose personal information about a consumer, but not to all kinds of operations performed on that personal information. The GDPR is also principle-based and includes the requirement that any processing performed on personal data be based on one of the 6 legal bases that are available. So for example, consent, legitimate interest, performance of a contract, to name a few. CCPA does not have such requirements. So the main difference here is CCPA regulates specific aspects of the processing, so sale is a good example, but not kind of the overall treatment and processing of data that the company holds as GDPR does. So GDPR also has many more requirements in comparison to CCPA. For example, controllers and processors must maintain a record of their processing activities. There's the requirement to perform DPIAs in some circumstances, having some type of safeguards for any transfer of personal data outside of the EU, breach notification requirements, appointing a DPO, etc. So the CCPA is more focused on providing rights to consumer to protect them from data misuse and to require transparency from businesses regarding their use of personal information. So a bit more focused in that sense. There's another main difference that has to do with vendor management. We'll touch on that a bit later when Andrew talks about that. So the CCPA itself doesn't include all obligations that exist in GDPR, but just a quick note though that California has other laws that cover some of these areas, and a good example being the data breach notification law. So while the goal of GDPR was kind of to take a broad overall approach to regulating the processing of personal data, businesses that are subject to CCPA or operating in California, they still may have more privacy or security-related obligations than those strictly contained in CCPA only. So finally, to close on the subject of the overlap and differences between the two, I want to just give a quick word of advice and remind that the devil is in the details. So even if there are some apparent similarities, it's very important when it comes to strict compliance and implementation within your organization to look at the specifics of each carefully when it comes to scope, definitions, exceptions. Dominique made a good point, explained that the right of erasure for GDPR only applies in certain circumstances, and gave a good example of how that can kind of come back to your face even if it was not intended. So we're going to look at how to address both laws in the most efficient way. So there are some practical steps that you can take to implement both pieces of legislation within your organizations, because again, while there are some differences in each in terms of the specific requirements, when it comes to the processes that you can put in place internally to comply, those can be leveraged to cover both laws. So to facilitate things to the extent possible, it's good to work on compliance with a holistic approach, and ideally as part of one kind of global privacy program. And as we're about to see in just a moment, there are lots of areas that can be approached, again, globally, and then the actual process itself will incorporate the differences between the two laws. And now I'll let Andrew start with that.
Yes, thank you for that. Important to go over those key overlaps and differences. And now we'd like to take a look at the operational steps that are important in reaction to these rights and kind of get to the action that you can be taking right now. So a good place to start would be to understand what your organization does already and has in place. One of the reasons for this format and thinking about the GDPR in relation to the CCPA is that we're trying to see where you might be able to leverage work that's been well done or something that you've used before that can be tailored for this is usually a good place to start. And a readiness assessment is a great way for you to figure out where your gaps are and make sure that you understand the points that need to be addressed and the measures and processes that you need to put in place in order to be ready. Some of these resources will focus solely on the CCPA. Other resources are more comprehensive and will allow you to assess readiness with one questionnaire against multiple regimes like the GDPR and the CCPA. So that sometimes can be the best approach because it'll give you the best overall view as to where your organization is in its readiness. And when you think about starting, it's important to think about starting now. So there's something that's referred to as the look-back requirement. The look-back requirement, I think an example would be the right to request access, looks back 12 months, so the previous 12 months. And since the enforcement date is January 1st, 2020, you should be already trying to get your records in place, make them accurate and findable in such a way that this is going to be something that you can achieve on the effective date. And so perhaps the best way to make things findable is to start with updating or maybe to just beginning a data inventory and a record-keeping process at your company. So if you have experience with the GDPR, you'll be familiar with these steps and you'll already have a great starting point. So you shouldn't be reinventing the wheel here, but as you've seen through previous presenters, there are important details that are different here. So you're not simply extending the same points in order to cover this. There are some new obligations that need to be captured. And it's also worth pointing out that this is an activity that's in support of other activities, right? So this is something that needs to be done in order to carry out other requests. It's not in itself, the requirement that you're trying to meet. It's the thing that's supporting the requirement that you're trying to meet. So the first step here, creating a map, a record of processing activities, is so that when you are going to receive a data subject request, you are able to do proper fulfillment of that request. If there is a breach, that you'd be able to map back where necessary and learn as quickly as you can what's going on. And when we talk about risk assessments and PIAs later, having good awareness of the processing that's happening within your company. And if GDPR is not an area of overlap for you, you may find that there are some things you can leverage on the security side of things. Many companies will have a program such as ISO 27001 that at least had an asset map that can be a starting point that leads you down the road to collecting the right information that would be important for your records in this case. So to highlight a few, we should be looking here at understanding the categories of personal information that's collected, but also importantly what is sold, the specific pieces of what's collected, the categories of the sources, the purpose for not only collecting but also selling, and the categories of third parties with whom you have shared. So you can think about this as in the context of the example of the right for information request, and I think it becomes clear how this would be useful. I should also point out from a practical point of view that this is another area where integrations with other processes and tools can be important. The obvious integration here being one with how it is that you're going to receive your data subject requests. You may want to try to get some integration in place there to make that more helpful. So to look back across what's important, we're talking about enabling the fulfillment of consumer rights requests through this data inventory. We're identifying the flows and where and whether something is sold. And again, we're looking to get this done as soon as possible due to this look back requirement that says that your records need to be in order. So I will hand this back to you for a few additional tasks, Benedict, and then I'll pick it up again for the end.
Yeah, great. Thanks, Andrew. So our third step here is to look at your privacy notice and policies generally. So both CCPA and GDPR have requirements around the information that, as a business, you need to disclose to individuals. For the sake of time, I won't give too much details on those, but in CCPA, businesses must disclose to consumers the categories of personal information we collected, purposes of the use, the rights consumers have, and that the business sells personal information, and that consumers have a right to opt out. There's some information to disclose in the online privacy policy if the business has one. So this is, all included in CCPA. And GDPR addresses the information to be provided to individuals in Articles 13 and 14. It's a bit more broader than CCPA. It includes things like identity and contact details of the controller, the purposes of processing, as well as the legal basis, and of course the rights that people have. So, main point here from a kind of standpoint is to kind of, take a bigger view of this, look at your notice and see how you can kind of incorporate all the requirements from each and organize it in a proper within the notice, so it works for both EU residents and California residents as well. So for example, having kind of a big your rights section, and depending on how as a company, whether you want to take a global approach, grants rights to more people than you have to or not, organize your notice accordingly. One, and of course, we've talked about this extensively, and rights are really at the heart of each of these laws. So one, crucial aspect here for whether it's for data subject requests under GDPR or consumer requests under CCPA, but it will be for your business to have a very solid process in place to kind of handle and manage those. So there's several things to consider for that purpose. So first one is how, as an organization, you're enabling or facilitating those rights/requests from people. So CCPA does require at a minimum that you provide a toll-free telephone number and a website address if your business has a website. GDPR, only mentioned that you do need to facilitate and enable those. It doesn't have specific requirements like CCPA does, but you can think of different ways. You can offer a standardized web form on your website or other means of submission. You can have a dedicated call center, customer support in person, etc. But those are definitely aspects to think about. The second aspect is what is expected of your employees who will receive the request and how to handle them. So that, implies, depending on the nature of your business, to understand who within your organization, what type of employee are likely to receive this request, to make sure that you don't miss one. Again, under both laws, it's very high fines or sanctions, so it's very important not to miss one. There are strict timelines to respond to individuals, so need to make sure that you capture those. The review process for each request as well, so what action should be taken, what kind of workflow process you want to take to manage those. Under GDPR, you kind of need to make sure, it's called verifying the identity of the person, so basically just making sure, of course, that the person that you received the request from is the actual person that's making it. Under CCPA, it's called a verifiable consumer request. There will be more. The AG is expected to take issue regulations to explain the details on how to verify those, but there is kind of this step of verifying the identity of the person. Also, whether a fee is applicable. So for both is supposed to be free of charge, but then if you get manifestly infounded or excessive requests or to cover administrative costs, if people ask for additional copies, for example, those are instances where you may request a fee. So that's another thing to figure out. And then how requests will be carried out internally. So that's obviously the key. As Andrew explained a few minutes ago, this is nice when you have proper data inventory, so you know exactly where to look and who to ask to obtain the data, delete the data, rectify it, etc. And finally, the response piece and responding to data subjects. So you need to make sure that you have a secure and effective process to respond and transmit data if applicable. And as I mentioned quickly as well, the required timeline. So GDPR, the standard is 30 days, CCPA is 45 days. So, to, again, kind of approach this as a whole, it's good to think about creating different template responses so that you can standardize as much as possible those responses to people based on which regulation is at stake. And maybe you also want to think about putting this overall process or checklist into a company policy or SOP. Our kind of fifth step here is provide this opt-out mechanism. So this one is specific to CCPA, which has a very precise requirement that the business provide a do not sell my personal information button to enable consumers to easily exercise this right to opt out of the sale of their personal information. So if you're using a tool to manage your consumer or data subject requests, you may think about kind of tying that one to your standard workflow as well to capture it there. And just a few very important considerations here will be to accurately track when that opt-out is made by a consumer. And there's two main reasons here. And one is the business that needs to stop selling that personal information after the request is made. So that's pretty obvious. And the second one is that you have the possibility as a business to reach out to the customer 12 months after to ask if they would authorize the sale again, but that implies knowing when it's safe to do so, so when the opt-out was made precisely. Andrew? Oh, Andrew, you're on mute? Oh, yeah.
Yeah, thanks. Let me pick up with training. So training is often dealt with as something that would be good to have. In this case, it is a requirement to have. So we should definitely take a moment to make sure that we understand this piece. If you look at 1798, 130, and 135, you'll see that the scope is not everyone in the entire company, but the individuals responsible for handling the consumer inquiries. So that's important to note. And those individuals need to be informed of all the requirements and how to direct consumers to exercise their rights. So in this case, we're going to certainly focus on that training aspect, but there's a secondary piece here which implies that there's probably policies and processes that need to be updated in order to make these changes, and also perhaps updating to marketing as well to make sure that communication is happening. Additionally, it's probably a best practice in this case to set up some sort of verification that the training is working. Quizzes could be collected. There might be a regular schedule that's put in place. And this is an area where, because the GDPR didn't have a specific requirement, you might not be able to leverage some of your previous work. That said, I do think that one of the things to focus on would be the recognition of the request. Already we've noted the discussion about needing to have an 800 number, or if you have a website, a place to make a request via the web. I think this is an area that we'll want to spend a little bit more time learning about once there is additional information and details on what this needs to look like. But I think it's possible that there'll be other means that these requests are coming in, and you want to make sure that employees are not missing out. All right, just a few quick additional actions to be taken. PIAs and privacy by design is not one of the required things, but it's a piece that helps manage overall risk and is going to assist with the overall program strength in responding to the CCPA. So specifically, you're probably going to be looking at proactively embedding privacy throughout the business. This is the goal of privacy by design, but the tasks that you'll be carrying out are integrating probably tasks like privacy impact assessments throughout the business to make sure that you're taking care of these things. And a way to map this back, I think, is that although there isn't a specific requirement for privacy by design, it does show up within the CCPA that there are the fair information practice principles, and in order to react to those principles, this is one of your best approaches. It's also a good time to remember that you are not alone in your obligations here. This is a shared responsibility, and take a moment to look out at your network of privacy champions if you have them. If you don't, this would be a good time to start building them, and make sure that your goal of baking privacy into all the areas of the business is carried out by making sure that there are other people that are, an extension of your team that are aware of what needs to be going on, and possibly will be participating in that training that you just spoke about. And then the final piece here is that vendor management is something that was very clear in the GDPR. If you go to Article 28, the requirements were very precise. The contract had to include specific subject matter, talk about the duration of processing, the nature and the purpose of the processing, the types of personal data, et cetera. In the CCPA, there's a little bit lighter detail on how this works, but as Dominique pointed out earlier, it's an incredibly important piece of the puzzle. So you're going to want to make sure that, for example, if there's a deletion request, that you're going to be able to go to your vendor and they're going to know how to work with you and have the obligation to work with you. And I think that review is best carried out through a comprehensive process of vendor management. Two other quick items. Obviously, OneTrust has put together a full response solution for this, but there are some tools that are made available specifically that I think would be nice to highlight. One is our mobile app. It's got quick search, the full text of the CCPA. You can highlight and bookmark things, get news updates, and hopefully get a chance to operationalize some of the things that we spoke about today. And as you're working towards a lot of these new program objectives, it sometimes helps to talk to others, and we've announced our 2019 schedule for Privacy Connect, which has 100 plus events, 80 cities, and good coverage of the CCPA. So hopefully we can share some practical tips there, and you can also sign up to participate in monthly thought leadership webinars in that case as well. So I guess I'll hand this back to you, Dave. Thank you.
Terrific. Thanks so much, Andrew, and thanks, Benedict and Dominique. That was a fantastic, very rich, information-filled hour. I hope that those of you that dialed in got a lot of what you were looking for. We got a number of questions that came in throughout the program. We've answered some of them in writing, and we're just about finished with the hour here, but what we're going to do is we're going to export some of the questions and go through them, and we're going to try to respond to as many as we can in writing on the OneTrust website. So hop on over there onto their educational programs page and look for some answers to those in the future. Additionally, as you can see on the slide right in front of you right now, all of our email addresses are available. Those are live links, so I might suggest that you go ahead and click on one of those email addresses to queue up an email and get your question in. I'm sure that Andrew and Benedict and Dominique would be happy to respond to you as they can. So please get those in, and again, we're going to do our best to tackle the questions that we weren't able to answer directly in writing following the program. So a huge thank you to OneTrust for supporting this program today, making it available to all of you for free. We here at the IPP very much appreciate the support of OneTrust. It's a great partnership we have with them and for providing this information to you, our membership, and the audience out there today. So thank you very much, OneTrust. Andrew and Benedict, it's great to have your support. And to all of you for taking some time to be here today as well. I wanted to ask if you have just literally 2 minutes left to let us know how we did on this program today. That's a link in front of you to a quick survey with just a few questions to let you give us some feedback about whether we met your expectations for today. So if you wouldn't mind just clicking on that and giving us that feedback, we would very much appreciate it. There is a field in that survey that allows you to let us know what topics you'd like to hear about on future privacy education webinars, and we look at that regularly in order to build our educational programs. So please hop on over there, let us know how we did, and let us know what topics and subjects you'd like to hear about in the future. As I mentioned at the beginning of the program, if you are an IAPP certified privacy professional and you registered for this web conference, you will automatically be granted 1 CPE credit toward the upkeep of your certification. That's going to be taken care of you automatically. If for some reason you're listening to this recording, you can still get that CPE credit by going to the IAPP website into the certification tab and filling out a very quick form, and we can grant that credit for you. If you're an attorney and you're wondering about continuing legal education or CLE credits, we do not pre-certify these web conferences, so you'll need to apply in your particular jurisdiction. And if you need supporting materials, they can be found through live links under the video viewing window of this recording, if you're viewing it online now. And you can also feel free to contact me, and I can do what I can to help provide them. So Andrew, Benedict, and Dominique, thank you all so much for sharing your expertise with us today.
For having us.
Thanks, Dave. Thanks.
And with that, we'll take us to a program close and hope to see you on another